Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time it takes from a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? Do you feel like there is a divide between lawyers and their clients? Then this TV show is for you. It is all about empowering you and your business with the knowledge and tools to ensure that this doesn't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show that will give you some actionable steps to consider for the week for your business. And at lunchtime on Wednesdays, we present our in-depth show of between 30 minutes and an hour, where we go through complicated legal aspects of your business in a simple to understand, plain English manner. And whether that is through educational pieces or interviews with experts in their fields. Hi everyone, and welcome to Business Legal Lifecycle TV and our podcast. I'm Jeremy Stratton, one of the founders of Business Legal Lifecycle, and I'm here today and for our Wednesday show because it's Wednesday. We're in the month of July, so we're doing a show based on the theme for this month, which is estate planning, phase 8 of the Business Legal Lifecycle, and phase 12 retirement. Today we've got a bit of something different. I'm going to interview my business partner, Craig Mason. Craig is a solicitor based in Brisbane. He's been my business partner for nearly 7 years in our firm Stratton Mason Lawyers and through the Business Legal Lifecycle. Craig, one of the specialties that he works in is estate planning and setting people up for retirement. So we thought it'd be good fun to interview Craig, go through some different topics and really run through the kind of things that he does. So the things you're going to get out of this is why estate planning is important. That's number one. The second is what happens if you pass away without a will. A lot of people don't realize what the consequences of that are. So you need to really be aware of that so that you know where you're going moving forward. And finally, we go through the estate planning process. And really I dive deep into, and Craig dives deep into what actually needs to happen in that process to make sure that you get the right plan for you and for your business and for your estate. So look, Craig and I, we've been working together for 14 odd years. We've been business partners for 7, for half of that. And so, we have a lot of fun with this interview, and I think you'll enjoy my interview with Craig Mason. Welcome, Craig. I'm looking forward to interviewing today on this interesting topic of estate planning.
Thank you, Jeremy. I'm very honoured to be interviewed by you on the show.
Excellent. Well, let's start with estate planning and your business. As I said in the intro, one of the specialties that you do in our law firm is estate planning. So that's why we're interviewing you today. So can you talk about why estate planning is important, especially for a business owner?
Yeah, so estate planning, it's something that you may not want to think about. Obviously, it's about, if you were to pass away, what's going to happen to your assets, or if you lost capacity, or who can make decisions for you. So it's not a great thing to be talking about, but I know, having spoken to a number of clients about estate planning and the peace of mind that it gives them once they get it all done, shows the importance of actually sitting down and doing it. So when you're doing estate planning, you're looking at wills, you're looking at powers of attorney, so that's general and enduring powers of attorney. You might be looking at advanced health directives as well, also thinking about insurance and those sorts of things, life insurance or permanent disability insurance. So all those sorts of things form part of your estate plan. Same with your superannuation, which is becoming one of the larger assets of a lot of people, a lot of business owners. So you've got to consider your superannuation, what would happen to that if something happened to you. So it's important because your assets are getting a lot higher. Life insurance, superannuation, those sorts of things are becoming more popular and becoming quite large assets. So it's very important to have a look at all those sorts of things.
Yep.
And make sure you've got a plan in place if something was to happen to you.
Great. Yeah, I think that's excellent. So the focus of our show obviously is about business owners. So why is it important if you're running a business?
Yeah, so obviously as you run a business, hopefully not only is your business growing, but you're also using the profit or the funds from the business to acquire assets in your own name as well. So it becomes important for any assets in your own name. You need a will that's going to dictate how they're going to be dealt with. But also in your business, you might have a company that's a single director company. So you need to take some steps there about who's going to become a director. So potentially the company can continue. If you're a sole trader, which going back on some of our previous shows is not one of our recommended structures, but if you are a sole trader and operating a business, then the will becomes particularly important in that sense because your business is owned by you personally, and therefore your will govern how that business is to be handed down. So if you want it to go to a particular person, etc., then you're going to have to take some steps in your will and consider how that can actually occur. So you need to do some succession planning about handing the business over to your children or whoever it might be, and the best way of dealing with that. So same with a lot of business owners these days will have superannuation, self-managed super funds, those sorts of things. They become particularly important as well about your estate planning. It's obviously a business is an asset, so you need to consider that, and it's important to make sure you think about that when you're doing your estate planning.
And with single director companies, what do you think is the best way to resolve that? Is that something that goes into a will? Is it thinking about the shareholders? Do you want to just quickly talk about that? Because there'd be a lot of people who watch our show, as you know, who would be single director companies.
Yeah, well, you just need to work out who you want to be as the director. I mean, that comes back to the legal personal representative of your estate, which is your executor. So who you're appointing there might be able to appoint a director and continue the company.
Yeah.
So it's pretty important to consider and pick the right sort of person in that sense.
Yep. Excellent. So, we talked about last week, we didn't go into a lot of detail, but what happens if you pass away without a will, and who makes the decisions regarding your assets?
Yeah. So as Jeremy said, last week we did discuss, passing away without a will, and there are some major ramifications for doing that. One of which is, who actually gets to make the decision regarding your assets. So normally if you have a will, you appoint an executor to your estate. So they're the person that basically gets everything together, sells any assets, etc., and then administers the estate in accordance with your will. So if you don't have a will, obviously you haven't appointed someone. So there is a process that when we're talking about in Queensland and most other states and jurisdictions, there is a process as to who can actually apply to be appointed that person. And when I say apply, I mean apply to the court. So obviously the costs and the time spent increases when this happens, because you now need to make an actual application to the court about, and basically there's a list in Queensland as to who has first priority to apply and so on. So you need to, if you're not the first top person, then you need to tell the court as to why those other people aren't applying, or if you're the first person, then you can apply in the first instance. So there's a list. As I said, it increases the costs and the time spent to try to administer the estate. There could be competing interests about who wants to apply. Different children might want to apply, parents, all those sorts of things. So it's, if you want someone to do it for you and make it a lot easier, then you need to have the will in place in order to appoint a particular person. And when you're appointing an executor, you need to consider how old they are, where they are, those sorts of things. There's no point appointing your parents and they're 82. There's a rough chance that they may not be around when you pass away. So probably not appointing that. Or if you do appoint someone like that, then you need to think about appointing a secondary executor if something happened to the first one. So the executor, it's a pretty important thing to put in place. You want someone that you think can handle it. There are some, quite vast array of decisions and things they need to do, from organising funerals to, selling property. So it can be onerous. Obviously, you get them to, or they should speak to consultants and get the advice about that. But yeah, definitely better to have a will and appoint an executor.
And often you and I hear people say, oh, well, that's not my problem. It'll be my children's problem or my spouse's problem down the track. As far as costs go, how much more expensive is it to apply for intestacy? How much more complicated is it? Just from a cost point of view than if you have a will.
Yeah, look, it depend on the circumstances, of course, but you'd be looking at probably almost double the costs potentially, depending on what needs to be done and who else is out there. But definitely more.
And that's costs that come straight out of the estate. So that's money that your family or friends will not have if you make them go through that process, isn't it?
Absolutely. Yep.
Yeah. So that's something that a lot of people don't realise. So I just thought that would be good for people to realise that it's double the cost and it comes out of the estate. Someone's got to pay for it, and that's often the estate. So if you do, continuing with our theme of passing away without a will and going a bit more in depth into that, what happens to your assets and who receives them if you die without a will?
Yeah. So as per the last question, there's a set of rules that applies, and these are called the intestacy rules. And again, there's ones in Queensland and there's ones throughout Australia, and no doubt in other jurisdictions as well. So this governs if someone passes away without a will, what happens to the actual estate. So a lot of people think if you pass away without a will, it automatically goes to the government. That's not the case. It could be if all of these other people don't exist. So you'd have to have no family whatsoever, then it could go to the government. But in reality, it normally goes to someone else before then. So if you've got a spouse and no children, then it's going to go to your spouse. If you have a spouse and children, then the spouse gets the first 150,000, the household contents, and then depending on how many children, either half or a third of the residual. So, and it goes down from there, parents, brothers, sisters, etc., etc. So it's got to get through all of that before it gets to the government, essentially. Yep. So if you want to give specific things to specific people, then there's no way, if you pass away without a will, that's just simply not going to happen. Yep. If you have someone that you don't want included in your will that is a family member, and you don't have a will, then it's going to go down to the intestacy rules. There's no leeway, I guess is the best way of saying that. It's a strict set of rules in the legislation. So yeah, in some instances, if it's a family with husband, wife, and a couple of kids, and you don't have a will, then 9 times out of 10 it's going to go probably the way that they would have done it anyway. But if you want to give any specific assets to anyone or exclude anyone or anything along those lines, then it's definitely not going to go the way that you want it to go. Yep.
Yeah, and that's something that a lot of people don't realise. They think, oh, it'll just go to my spouse, but they don't realise what the actual rules say, do they?
No, absolutely not.
Yeah. So let's give a real example of where the fact that the person didn't have a will meant that the estate was not administered as that they would have wanted.
Yeah, so I mean, there's a number of those types of examples that I can think of, but one particular one, obviously we're not going to name names, but a particular person passed away without a will. At the time, they were separated from their partner, so not divorced, separated, and they were also unfortunately estranged from one of their children due to a variety of reasons that we're not going to go into in any detail today, but essentially it was at the doing of one of the children rather than the actual parent. So unfortunately, they passed away. They didn't have the will. So as I just said in the previous question, the intestacy rules therefore apply. Now the spouse, they were separated but not divorced, so they're still a spouse, and one of the estranged children obviously is still included as well, and receives part of the estate that they were entitled to in the intestacy will. So if they had a will in place, they would have appointed an executor that wouldn't have been potentially the spouse, or it may well have been, but if they were separated at the time, they may have appointed someone else, and they would have reduced the share that the child that they were estranged from receiving, to try to manipulate the estate that way. They wouldn't have given something to that estranged child for obvious reasons. So without the will, it had to go that way, and unfortunately, the person's obviously passed away, so they don't know what's going on, but the other family members that were around were quite upset that that's the way it had to go, but unfortunately, without one, and, that's the way it is. So, yeah, as I said, the person that's going to be the most upset about it is the person that's passed away. So it goes back to having that in place, thinking about it, and putting a will there. I know that you don't want to think about it, but faced with something like that, it's even worse when people get things that you didn't want them to receive. So pretty important.
And I imagine that whole process would have been quite costly as well, compared with what would have happened if they had just had a will in place.
Absolutely. So there's all the competing interests, who's doing what are we doing with this, those sorts of things. So there's, the cost increase and the time as well.
Yeah.
From normally an estate can be, sort of sorted out 6 to 12 months, that's sort of taking 24 months. So,
yeah, absolutely. So costs more money, takes more time, and is a lot more stress than it needs to be if you just do it beforehand. So let's move on to the next topic of estate planning itself. So let's go through some questions about that. What are some of the considerations that you go through when you're talking to clients regarding estate planning?
So when you're sitting down talking to someone about estate planning, you're obviously going to start with their actual assets, so the size of the estate. What do they have in their own name? Do they have property, cash at the bank, shares, those sorts of things? You also, as part of that, as I said in one of the previous questions about life insurance. So that's, as I said, becoming more popular and a larger payout. So that can be up to $2 million, which is considerable in that sense. So you need to think about those things. So you're looking at the size of the actual estate. You also then obviously need to look at the beneficiaries and who they are. Are they minors, or are they adults? If they're adults, do they have children? Those sorts of things. Is there any children that are estranged? Going back to the previous real life example, you need to think about that. And if there are they going to be left anything, or are they going to be left a smaller amount, whatever it might be? You need to consider that, because if you don't, then there could be some problems down the track when you pass away. You're looking at your super. So you might have an industry or retail fund. Do you have the binding nominations in place with your super fund? And the same goes with any self-managed super fund that you might have. Do you have the binding nominations? So are you giving that to your estate, or are you giving the super to your dependents, or your spouse? So you need to consider those sorts of things, because if it's coming to the estate, then the will obviously governs what happens to that super. But if it's going through the nominations to dependents or spouse or whatever, then that stays outside of the estate. So all of those sorts of things you sort of need to look at as to what the plan needs to involve. So once you get the size of the estate and who the beneficiaries are, you've talked about super and life insurance. You then, and also as part of that, you'd be looking at their other asset protection things that they've got in place. So any other discretionary trusts, companies, those sorts of things they have in place, to consider what their own, what the trust owns, etc. and also looking at the trustees as to, what powers are in there, who are the beneficiaries, and so can that trust continue if you passed away.
Yep.
And once you've got all of those sorts of things, then you're going to be tailoring what documents you need to put in place. So obviously one of those is going to be a will. One of those is also going to be an enduring power of attorney. And if they don't have the nominations in the super fund, then you're going to be looking at doing those. When you're thinking about the will, you'd also be thinking, is it going to be a normal sort of will, or are you going to include in that will what's called a testamentary trust? So that's essentially a will that has a discretionary trust tacked on to the end of it.
Yep.
So rather than your estate going to your beneficiaries in their own names, it goes into a trust with that beneficiary as the beneficiary of the particular trust. So it basically protects those assets going forward after you pass away.
Yep.
There's a variety of reasons as to why you might want to consider doing that, and that's part of the estate planning process. You're looking at the size of the estate, who are the beneficiaries if they're adults, and they're in an occupation that may be litigious, for instance, then you would consider a testamentary trust, because that protects their part of your estate from creditors, those sorts of things if they were to be sued. And it can have some benefits in a family law, divorce situation, property settlement situation.
Yep.
As well. And there are also tax benefits. So you'd be thinking about all those sorts of things. And then at the end of it all, you'd have your plan in place and your documents that will govern the best way of dealing with the estate. So there's a number of considerations you need to go through. It's an important process, even just answering those questions as to, you reveal when you're talking to clients some things that they didn't even realise in terms of what their estate is and how it's going to be structured. So there's lots of considerations.
Excellent. So yeah, that's a good comprehensive list of what people need to do when they're doing their estate planning. What about other consultants? So you and I are very big on working with our consultants and putting together a team of advisors. So are there other consultants included in estate planning, and what is their role in that process?
Yeah, absolutely. There are other consultants, and I would encourage anyone that's looking at this to involve everyone where they can, because there's no point, one consultant doing one thing if it doesn't match what the other consultant's talking about. So you've got your accountant. So the accountant is going to be talking about actual structures that you've got in place outside of your will. Also any tax implications through super, etc., as to if that goes to the estate or if it goes to the dependents, and generally any tax related issues in relation to your estate. You also got your financial planner, who may be looking after your assets and investments. How are they structured? They're normally involved with the super side of things as well. Are there nominations in place? Who is the super through? What's the balance? Those sorts of things. So you've got your financial planner involved with that. As part of that, you might also have an insurance broker. What insurances do you have in place? That could also be the financial planner from a life insurance point of view, but you need to work out what insurances are in place: life, permanent disability, even home, car insurance, those sorts of things. It's good to know that all of those things are in existence and who it's through if something was to ever happen. So you'd have your accountant, financial planner, and potentially an insurance broker type person involved. We're, as a firm, happy to have everyone in the same room and talking about it, and that can cut through some of the time spent as well. But we'd encourage everyone to always get as many people, your consultants, involved, because there's no point doing one thing if it affects something else. And a lot of times financial planners and accountants will have a full list of assets and structures and those sorts of things that they can send over, which makes it a lot easier when you're estate planning. So you definitely need to get everyone involved. And
yeah, that's excellent, Craig. So let's give another example of where you've implemented a comprehensive estate plan and what the benefits were for the client by doing that.
Yeah, so we've had recently a business owner. They had a number of different business interests, they had personal assets of some value, and as part of that, they also had an ex-partner, a current partner, and also 3 adult children. A couple of those children were at a high risk of litigation, so they were in the medical profession. So sat down with the particular client and their consultants and worked out exactly where everything was, what they owned, etc., what insurances they had in place. There was also some family law considerations as well that came into that one. So there was a family lawyer involved as well, from a, what are they called? I can't even think now. Binding financial agreement. So yeah, so that was involved as well. And so we went through all those sorts of things. And as I said before, with testamentary trusts, that's where this became particularly relevant. So the children, one, the size of the estate was quite large. There were adult children who were at high risk of litigation. So a testamentary trust was put in place so that if something happened to the person, rather than it going directly to the children, it goes into a trust for the children. And the benefits of that is obviously that there's now asset protection for the children going forward. They didn't need to set it all up. You did it, the person did it for them, I guess. So they're forward thinking and protecting assets for their children going forward. There were some tax benefits, and it also allowed for business succession as well for some of the business interests and going into the trust. So it's a real, really good example of where a testamentary trust is important and a necessary part of the estate plan. There were powers of attorney and those sorts of things done as well, but the main part of it was the testamentary trust and allowing the flexibility for that and the ability to protect the assets going forward. So,
cool.
Yeah.
Yeah, cool. All right, so let's talk about the final topic, second final topic, because I'm going to throw you into our lightning round, of someone facing death. So if someone's facing illness, what would you suggest that they do regarding a will?
Yeah, look, as I've said a couple of times, it's not the greatest thing to talk about, but if you're facing an illness that's, you know, you've given a period of time to live or something like that, I know you'd probably want to be thinking about other things, but you need to do something relatively quickly and get that out of the way.
Yep.
An informal will is really better than nothing. So if you can even just write something down and get it witnessed, that's going to be better than nothing. There are some. There's a case that we've spoken about previously in one of our legal updater shows about a text message that was classed as a will, and it was an unsent text message even, so it was on the person's mobile phone, hadn't actually been sent, and it outlined what they wanted in their will. So it's better to do something, but we encourage everyone, if the loved one is in that situation or you're in that situation, to speak to a solicitor.
Yep.
Most solicitors will can get wills done relatively quickly. They can organise for it to be signed and witnessed and put in place. So if I guess act quickly and just try to get something in place, particularly if you're wanting to do something that's a little bit more than just giving it to your spouse and to your children. You've got other assets floating around the place or a business, etc. Get onto it quickly, speak to your consultants, and as I said, just get something in place that is what you want. So
so get the advice, but if for some reason you can't, then just make some sort of note so that it may be at least the intention that you had at the time.
Exactly.
That's what you're getting at. Yep. All right. So just as far as concluding, going through this topic, is there anything else that's important that you want to add? You want to make sure that the listeners and viewers get today?
Yeah, absolutely. I think something that's important is you get all these things in place, which is great, and then you put it in your filing cabinet and look at it again. It's really important that once you do this, that you do review the estate plan that you have in place, sort of every two to 3 years, or where circumstances have changed. So if there's been a death in the family, there's been a marriage in the family, there's some more children, grandchildren, etc. in the family, or your assets have increased or decreased dramatically, then it's important to review your estate plan becomes particularly important if you have excluded someone from your will, to regularly review it, just to make sure that you're still happy with it. That's a big decision to exclude someone. So you want to make sure you're still happy with it, and you want it to be, that person to be excluded. It also shows if it ever does become a court matter that, you know, you've reviewed it every couple of years and made some notes to say, yes, I'm still happy, or whatever it might have been, or did a whole new will that's basically exactly the same, just a new date. Yep. And it shows to the court that that was your intention, you know, going forward. And it wasn't that, you know, 20 years ago you excluded someone, but then you reconciled and whatever else. So it's important to review it every couple of years, get your consultants involved, make sure nothing's changed, and that it still applies. You might have other life insurance or other structures in place. Yep. Make sure all that fits in. You may not need to do a whole new will, but we think it's an important process to go through to at least review it.
Yep.
We're happy to, you know, speak to our clients about it and review it. We're not there just to come up with some things to change just so you need to do a new will. We consider it an important process and part of the estate planning to actually review it every 2 to 3 years.
Yep.
Or where circumstances change. So, yeah, I think that's probably one thing that I didn't mention that's pretty important.
Well, excellent. Thank you. I think that's excellent information for everyone. And look, yeah, I have to throw you into the quick fire questions like I do for all the guests. So you ready?
Okay.
I didn't give you a warning that I was going to do that. So, so the first one is, how did you make your first dollar?
I made my first dollar shredding paper for my dad's law firm.
Maybe we should have that one out. No, just kidding. Getting rid of old files, no doubt. Nothing. Sorry.
Yeah, of course. Yeah.
Excellent. All right. So you can't answer the business legal life cycle, but what book do you think that every business owner should read?
Start with why.
Excellent answer. Yep. And if you could give advice to your younger self, what would that advice be?
I think, maybe make every second count or every minute count. Can't think of the book now, but just really acknowledging the fact that, you know, your life's not going to go on forever, and you need to take it seriously at a younger age, I think.
I think there's many books that talk about that, but yeah, that's good advice. So finally, if people want to talk to you about estate planning, what's the best way to get in contact with you?
Variety of ways. I mean, you can go through Business Legal Lifecycle and get in touch through those, or you can contact me through the law firm. So it's Stretton Masons Lawyers. Our website is www.smslaw.com.au, or go through the businesslegallifecycle.com page to get in contact. And as always, if there's any questions or comments on Facebook or wherever else you might be listening or watching this, please do so, and we can come back to you if you've got a question.
Great. All right. Well, thank you, and we'll speak soon.
All right. Thank you.
I hope you enjoyed that interview with Craig. As you can see, Craig knows a lot about estate planning and can really nail it down to some really plain English aspects to make sure that you get the right learnings and what you need to get for the estate planning process. As I said in the intro, the three things that you hopefully take away from that interview is, you know, why estate planning is important and what it is, what happens if you pass away without a will, and why that becomes really important. And then really through the estate planning process. And so as you would have seen, Craig and I go through what actually happens through the estate planning process so that you can understand what it is and why you need to do it. As always, we take the show notes for you. So if you go to businesslegallifecycle.com.au/111 for 111th, because this is the 111th show, you'll be able to get the show notes. There's a workbook for today's episode, which I have posted here on the Facebook page, and you can also get at the show notes page. You can always download the workbooks there. Really interested to get your feedback on this style of show. We haven't done a proper interview of each other to go through in a bit more detail on what we're doing. So please, if you like this, please like our Facebook page. Please like the video. Send any comments that you've got to lifecycle@jeremystratton.com. And yeah, we'll be back on Monday with another Fast Fix Monday, where we're going to talk more about estate planning and retirement. So have a good week, everyone.